Hi guys, I'm GAURI and I'm a legal intern at LEXIS and Company. I'm from Symbiosis Law School, Pune. And today's video is about Article 262, which is the river water dispute. Water, it does not stay at one place. It is usually rivers. They are usually in a state of flow. And therefore, no state has an exclusive ownership of such kinds of water. And there is no state that can legislate for the use of such waters, since no state can claim legislative power beyond its territory. For example, there's a river. There is state A, B, C, and D. Alright, state A, it can only have legislative power till its territory. Like, for example, a river, it passes through A for 5 meters. It has only legislative power for 5 meters for that river. And the next state, that is B, it has for the river flows through it for 10 meters. So it has only legislative power till 10 meters. And the Constitution confers legislative power over such rivers only to the Constitution. Articles 261, 262 uh, 262(1) empowers Parliament to provide by law for adjudication of any dispute or complaint with respect to the use, distribution, or control of the waters by any interstate river or river valley. This provision confers an exclusive legislative power on Parliament to enact a law providing for the adjudication of disputes relating to use, control of waters, distribution of any interstate river or river valley. And what do these words, these provisions indicate? They indicate the amplitude of the scope of adjudication was much as it would take within its sweep determination of the extent and the manner of the use of said waters and the power to give directions in respect to the same. Now, Section 262(2), the Parliament may, it states that the Parliament may also provide that notwithstanding anything in the Constitution, neither the Supreme Court nor any other court shall exercise jurisdiction in respect of any such dispute or complaint. The decision of interstate disputes by the Supreme Court is provided under Article 131. They have the jurisdiction over it. But Article 262, it provides that the class of disputes mentioned therein may be excluded by the Parliament from the purview of the Supreme Court. The Interstate Water Dispute Act 1956. It was enacted under Article 262. What does it provide? It provided for adjudication of disputes relating to the use, distribution, or control of waters of interstate rivers and river valleys among the concerned state governments. Section 3, it provides if any dispute arises, a state government may request the central government to refer it to a tribunal or adjudication. Section 4, it states that if the central government is of opinion that it cannot be settled by negotiations, it would constitute a tribunal for the purposes. What does it mean? That Section 4 it vests the power for setting of tribunal with the central government, and this tribunal has to be made if there is the requisite opinion by the central government. The tribunal, it should consist of chairman and two other members nominated by the Chief Justice of India, and from they should be among the judges of the Supreme Court or the High Court. And the tribunal may appoint two or more accessors to advise it. Section 11 of the Act, it states that notwithstanding anything contained in any other law, neither the Supreme Court nor any other court shall have any jurisdiction in respect of an interstate water dispute which may be referred to by a tribunal. And this provision, when it is read with Article 262, it bars the jurisdiction of all courts, including the Supreme Court, to entertain adjudication of disputes which are referable to a tribunal under Section 3. The In the matter of Kaveri Water Disputes Tribunal, it constitutes an important judicial pronouncement in the area of Indian federalism. Yeah, and for federalism, you can visit the previous video. It talks about federalism. Uh, it was based on that. This was a long standing dispute between Tamil Nadu and Karnataka, and also for Pondicherry. And in 1990, a writ petition was filed by Tamil Nadu Riots Association for the Supreme Court to take into consideration the courses of negotiations between various states and the length of time which had passed. It was held that the negotiations between the two states had failed and therefore directed the central government to constitute a tribunal under Section 4 of the Interstate Water Disputes Act 1956. The tribunal was constituted, and now the tribunal, it referred the interstate water disputes for the adjudication. It had the adjudication to try it. The tribunal made an interim award as regards to distribution of Kaveri waters between the concerned states. Karnataka, it did not accept this, and with the view to make it ineffective, Karnataka issued an ordinance, and that ordinance was converted into an act later, charging the state government with the duty to abstract every year such quantity of water as it may deem requisite from Kaveri, notwithstanding anything contained in any order or decision of a tribunal. The purpose of the act was to override the decision of the tribunal and its implementation. The act sought to define and nullify the interim order, and the it also had the effect of reserving the Karnataka exclusively the right to appropriate as much water from Kaveri as it deemed necessary pending final adjudication of the tribunal. Also, Article 262, it authorizes Parliament by law to exclude the jurisdiction of any court, including the Supreme Court, in respect of any dispute or complaint for the adjudication of which provisions is made in such law. I hope today's videos regarding Article 262 was clear. For any doubts or any questions or any feedback, please use the comment section. I'll try to respond to it as quickly as possible and as soon as possible. This video is for educational purposes only. Okay, guys, see you in the next video. Bye bye.